He said it's only because he plays a lot of golf. I said, I don't know.
The guy I am most impressed with, and I am most impressed with you.
And the first thing he wanted me to make sure that I told all of you is that on Wednesdays of every week, at 12 o'clock noon at the Chabad in Madison is a Talmud reading. And you should all put it in your lawyer's diaries and see if you can make that event. And there happened to be two older Jewish gentlemen that were attending one of Rabbi Lubin's Talmud readings last week, and as they were coming out of the Chabad, they were walking down the street, Morris and Irving. They're walking down the street, and they come across a Catholic church, and there's a big sign in front of the Catholic church that says, "Special today." It says, "Convert $5,000. And Irving looks at Morris. He says, "Can you believe that? That someone would, that another religion would pay to convert to another religion?" And Morris says, "Yeah, isn't that horrible? What do you think Rabbi Lubin would think of that? Just terrible." He says, Morris says, "However, Irving, things aren't that good." He says, "I could really use the money." Irving said, "How dare you?" He says, "No, really, things at home aren't good. We could really use the money." He says, I think I'm going to do it. I could really use the $5,000. Irving says, "You can't go in there." So there's a bench outside. Irving sits down, and Morris says, "I'm going in." So Morris goes in, and he's in there for an hour and a half, 2 hours. He finally comes out, and Irving looks at him. He says, "Well, did you convert?" He says, this pious look on Morris's face, says, "Yes, I did." He says, "Well, did they give you the $5,000? He says, "All you Jews ever think about is the money." All right. Having said that, I want to welcome you all to the Jewish Law Symposium, an event of this magnitude. Look around you, just doesn't happen. The Jewish Law Symposium in the middle of June, with over 200 people in Morris County, featuring a Supreme Court Justice and the learned Rabbi Shlomo Jaffe. How does that happen? Who could organize such an event? Who could possibly do that? Who has got the dynamic wisdom and the fortitude to put something like this together? Last year, I think there was about 70 people. This year, there's about 200 people that have signed up and registered. His name is Rabbi Shalom Lubin. And when Rabbi Shalom Lubin asked me to provide these opening remarks, my question was, why me? Why me? Out of all these, I guess it's who's who or who's Jew in Morris County. And he said, "Well, you know me. You know who I am. You know me. And just say a few nice things about me and say a few nice things about the program, and that's all you have to do." Well, when I went home last night after I got the message, I did start to think about Rabbi Lubin, and you know what? I do know him. And I've gotten to know him very well over the last 2 years. And I realize what a special man that he really is. He's a man with vision. He's a man with endless energy. He's a generous man to the Morris County community and a scholar, and he's become a good friend. This is his event, and if you look around you, he has brought the Jewish legal community together in something that I tell you, it's all needed. I need it, and I think it's a good idea, and I think we should all continue this event into the future. I just want to tell you a true story, and this is how I became involved with Rabbi Lubin. About 2 years ago, my father passed away. He was a very religious man. He belonged to a synagogue down in Deal, where I grew up, at Temple Bethel. And my connection to the Jewish religion was basically through my dad. I would go to the High Holy Days with my father, and we would sit there on the High Holy Days, and that was a very special thing to me. And that was kind of my tie to the Jewish faith. And when he passed away, I really had a very void in my life. It wasn't the same, even going to the High Holy Days. About 2 months after that, I got a telephone call to my office from a Rabbi Shalom Lubin, who said that Jerry Kravitsky had told me to give you a call, and I just want 5 minutes of your time. I don't know anybody else by the name of Shalom, but when Shalom calls and wants 5 minutes of your time, I thought it was a good idea to make that happen. So I met Rabbi Lubin, came to my office, and we met, and we talked, and we met again, and we talked, and we met again, and we talked. And this happened several times, and it became, these talks really brought me back to my faith. So Rabbi Shalom Lubin, the executive director of the Chabad of Southeast Morris County, I commend you on all you have done today, and I am honored to introduce him as our host. I am honored to introduce him as my new rabbi, and perhaps someday your rabbi, and I introduce to you Rabbi Shalom Lubin. Thank you.
Thank you, Billy, for the beautiful introduction. I am reminded of the words of Lyndon Johnson, who was once introduced in similar fashion, and he says his only regret was that his parents weren't at the event to hear the introduction. He says, "My father would have enjoyed it, my mother would have believed it." I want to just welcome you to the Jewish Law Symposium, a project of Chabad of Southeast Morris County. It's truly an honor to welcome each and every one of you here tonight. I have two objectives in my brief remarks. One is to thank several people that have to be thanked, our sponsors and others, which I'll do in a moment. And the second one is to make sure that I don't put anyone to sleep in the process, which for a rabbi is no easy task. We tend to be pretty good at putting people to sleep. I actually have a member in my congregation who, every time I get up to speak, he falls asleep without fail. He's here right now, but if he were here, he'd be sleeping as we speak. And no matter what, bar mitzvahs, weddings, Shabbos, holidays, I'm speaking, he's sleeping, like clockwork. So one Saturday morning, I get up to the pulpit, and I look up, and he's sleeping. So I turn to him, I say, "Abe, I haven't even opened up my Bible yet. I haven't started. You're already sleeping." He says, "Rabbi, I trust you." Why are we here tonight? People have asked me over and over again, "Rabbi, why do you spend your time putting together a symposium for attorneys? Why is this important? Why do this?" And the answer, I believe, is very simple. The answer is that the Lubavitcher Rebbe, my mentor, my teacher, had a vision of uniting the Jewish community and really uniting all of mankind. And I believe the ideal way, the best way to bring people together is through education. We're all here tonight for one reason: to learn, to grow, to expand our horizons, to learn about the Talmud, to explore the Jewish legal system in a way that we haven't been familiar with before. We all have that in common. It crosses over beyond all denominations, beyond all faiths. Everyone is here together, united for one particular purpose. That's what I believe in as a rabbi. That's my mantra, my goal in life, and I thank you all for sharing that vision here with me tonight. I have several people I have to thank, and just give me a moment as we do that. I'd firstly like to thank my wife, Arona, who's just walking by, who has been behind this project from the beginning and has put in a tremendous amount of time to make this happen. It's actually our anniversary tonight. I promised my wife dinner at a lovely location with wonderful entertainment. And I don't know if she had this in mind, but I owe you one, and thank you very much for everything you do to make this project and all our projects happen. Our corporate sponsors, we could not have done this without you. MK Rosenfarb, formerly Rosenfarb Winter, Scott Mayer is here, thank you. North Star Litigation, Todd Goldberg is here, thank you. Insurance Investment Planners, IPC, Jeffrey Greenberg, thank you very much. DGR, Jerry Colasurdo, thank you for your support. Headquarters Title, Terry Detallo. Mercedes-Benz of Morristown, Danny Payton, Billy Strauss. Our photographer tonight, Tom Venero, thank you very much, Tom, for all your help. Videographer, Elm City Production, thank you. Eclipse Marketing and On The Mark Graphics for making it all happen. And Wolf Block for providing the CLE credits for this evening. I would like to thank all of our chairs and advisory board members personally, but that would take up the entire program. So I'm going to pass, and just thank you all for being involved in making this happen. I'd like to give one just announcement before I conclude my remarks, which is we're going to have a question-answer session following the two presentations. There are notepads on the table. We'll be collecting the questions after the second presentation. Feel free to write your questions up, and we'll answer them at that time. And a reminder, if anyone needs CLE credit and didn't fill out the form in the front, please do so before you leave. It's truly an honor for me as Rabbi, as director of this program, to introduce someone who needs no introduction at all, the Chief Justice of the New Jersey Supreme Court, the Honorable Stuart Rabner, to introduce our featured presenter this evening, the Honorable Justice Barry T. Albin. Thank you.
Thank you, Rabbi Lubin, and thank you for that wonderful idea about celebrating one's anniversary at a Jewish Law Symposium. My anniversary is 2 weeks from now, and I'm going to go home this evening, spring that on my wife. Please take her call tomorrow if it doesn't go over as well as I think. Many commentators have observed over the years that the New Jersey Supreme Court is among the finest in the nation, and that's directly attributable to the quality of the justices that have served on the court. People steeped in scholarship with an abiding sense of fairness, and Justice Barry Albin personifies these and so many other qualities. Anyone who's ever read one of Justice Albin's opinions knows of his formidable intellect and the truly gifted writing style that he has. It's no secret, nor is the fact that he is a person of unimpeachable integrity. His warmth and compassion are as readily apparent to those who know him as his scholarship is, and as they say in Latin, he is truly a mensch. It's been a privilege over this past year to watch him dissect complicated legal issues that have come before the court. In this setting, I think it's all right to note that Justice Albin can speak eloquently on both sides of an issue, but you always know that the decision he finally reaches, whether you agree with it or not, is thoughtful, penetrating, and wise. We are a better court for Justice Albin's service on it, and we're all better off as citizens of New Jersey for his role in public life. Prior to joining the Supreme Court, he was a partner at the Wilentz firm since 1982 when he joined there, assistant prosecutor of Passaic and then Middlesex counties. Before that, he was a deputy attorney general in the appellate section of the Division of Criminal Justice. He's a past president, as many of you know, of the Association of Criminal Defense Attorneys, a graduate of Rutgers College, Cornell Law School, and we are all looking forward to your remarks on the subject of democracy and the uncertain fate of individual rights. I can't think of anyone more qualified to speak on this subject tonight, and Rabbi Lubin, I can't think of anyone more qualified to speak at next year's symposium and the symposium than Justice Albin.
Chief Justice, thank you for those kind remarks. I think I'm going to designate you as my official introducer at all events. Thank you very much. Rabbi Yaffe, Rabbi Lubin, Chief Justice, judges, distinguished lawyers and guests, landsmen. Now, Rabbi Lubin, I'm still trying to understand how it came about that you booked this event at a hotel on Convent Road. Now, you may be wondering why I accepted this speaking engagement this evening. Well, you know that Rabbi Lubin is a force of nature, and he ardently pursued me with Hamantashen. And what can I say? Every lawyer has his price. You know, I think the last time that I spoke in front of a rabbi was at my bar mitzvah. And I hope I do not meet the same disapproval. The title of my talk this evening is Democracy and the Uncertain Fate of Individual Rights. Why have I chosen this topic? As a student of history and now a member of this state's highest court, I have given considerable thought to the judge's role in upholding individual rights, even when it is unpopular to do so. Each day in courts throughout this state and elsewhere, courageous judges make difficult decisions that will not meet with public adulation or popular approval. But they make those decisions because they are faithful to the Constitution and to the commands of our laws. However, on the great social and constitutional issues confronting one generation of Americans after another, the conception of the judge as a figure of philosophic solitude who applies the law indifferent to the swirling passions and sentiments of the time has struck me as not a correct reflection of reality. I have found that on those great issues, the historic reality is that courts are likely to reflect the democratic attitudes of the time and often become unreliable guarantors of our freedoms. We see that when popular support for the individual rights of a disaffected group evaporates due to some traumatic national crisis, the Constitution sometimes goes into hibernation. And when public support reaches a critical mass, courts are more likely to awaken and recognize rights that had lain dormant, sometimes for generations. And so I want to explore how courts have fared in vindicating individual rights when the democratic impulses of the day are hostile to a disfavored group or unorthodox views. Let me begin by discussing two distinctive features of our constitutional democracy. One is that the will of the majority prevails, and so the saying goes, the majority rules. When more than 50% of our elected representatives pass a bill, then it becomes law. And therefore we are governed by the sentiments held by the majority at any given time, with one very big exception. And that brings me to the other distinctive feature of our constitutional democracy, this commitment to individual rights. Those fundamental rights that we believe we hold as our birthright, those rights on which our liberty rests, those rights that are indispensable to living in a free society. Those rights, in theory, are not subject to the tyranny of the majority. They are supposed to be protected against the fiery passions that roil and inflame the public in times of domestic troubles and national crises. Those rights are enshrined in our organic law, our secular Bible, the Constitution. The Constitution guarantees due process of law and equal protection of the laws. It guarantees free speech and assembly and religious freedom. It guarantees the right to be free from unreasonable searches and seizure, and much more. But those constitutional rights are not self-executing. Under our system of government, we look to the courts to protect our fundamental rights, and in doing so to give shelter to the despised minority, to unpopular causes, and to the unorthodox views that may be opposed by the dominant party. We expect that the courts will be the bulwark of our liberty. From the beginning of the Republic, it was understood that independent and fearless judges would be necessary if individual rights were to withstand the shifting tides of public opinion. The fear of democracy running amok was one of the driving forces behind the adoption of the Bill of Rights. Various state conventions that endorsed the federal Constitution, some by very narrow votes, did so with the expectation that one of the first acts of the new government would be the passage of a Bill of Rights to protect the people from government oppression. In this new order, the Constitution would be the supreme law of the land, and statutory laws inconsistent with its commands would be rendered unconstitutional. In the Federalist Papers, Alexander Hamilton acknowledged that it, quote, would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it had been instigated by the major voice of the community. He expected that judges would guard the Constitution and the rights of individuals against those designing men, his words, who might try to manipulate an ill-informed public on some controversial issue for the purpose of instigating, his words, serious oppressions of the minor party. How have we measured up to Hamilton's conception of the role of judges? Many people think of constitutional rights as abstract, unchanging, timeless principles, a form of sacred scripture that judges can easily discern and apply. But constitutional rights are applied in particular cases and are shaped by the temper and the spirit of our times. And when attempting to divine the original intent of those who drafted the Constitution and its amendments, judges today are interpreting those documents through the consciousness, a 21st century consciousness. The passions and fashions and traditions of the world in which we live will affect, to some degree or another, the way judges apply constitutional rights. That is not judicial philosophy. That is historical reality and fact. Through interpretation by courts, the Constitution contracts and expands in different ways in different eras. That is my judicial theory of relativity. The public wants judges to stand up for individual rights, but not to stand in the way of progress or impede the vital interests of the country. However, the role of a judge as a protector of individual rights is not necessarily consistent with the judge who reflects the democratic ethos of his age. We do not want our right of free speech or the right to exercise our religious beliefs determined by the vagaries of a poll and the shifting winds of popular opinion. The wise and intrepid judiciary that Hamilton imagined needs to operate not just in the best of times, but also in the worst of times. For it is in the worst of times that constitutional rights are most at risk. Too often, it has been in the worst of times that courts have fallen short of Hamilton's great expectations and failed to give meaningful protection to the majority's oppressions, to those who are vulnerable to the majority's oppressions, particularly those espousing unorthodox views or those who are just perceived to be different. Usually, individual rights are at greatest peril when there is a very real threat to national security or to the national existence, and the public is in the grip of a hysteria of fear. In the midst of a crisis, when alarm bells are ringing and when perfect knowledge is not attainable, it becomes difficult to gauge what is the real threat from what is exaggerated. Some exaggerations may be the mistake of well-meaning people, and others the work of those eager to exploit fear for some cynical purpose. History is rife with examples where a minority or disfavored group has suffered in a time of national crisis because the judiciary was unwilling to defend individual rights against the widespread sentiments of an inflamed public. After America's entry into the First World War in 1917, the administration of Woodrow Wilson, a progressive from New Jersey, ruthlessly suppressed speech criticizing the government's war policy. Those who expressed opposition to the war effort in ways that would be deemed inoffensive today were prosecuted under the recently passed Espionage Act. In 1918, Eugene Debs, who had been the socialist candidate for president just 6 years earlier, gave a speech in Canton, Ohio, publicly voicing support for several of his socialist colleagues who had been imprisoned for their criticism of the war. As a result, Debs was charged with obstructing the recruitment and enlistment of servicemen into the armed forces. What did Debs say that made him a target of the prosecuting authorities? He spoke mainly about his belief in the virtues and ultimate triumph of socialism, which in that day was viewed as a virulent philosophy and a threat to the existing capitalist order. He told the crowd that he had just visited his imprisoned colleagues, and he praised them in these words. He said, "They have come to realize, as many of us have, that it is extremely dangerous to exercise the constitutional right to free speech in a country fighting to make democracy safe in the world. I realize that in speaking to you this afternoon, there are certain limitations placed upon the right of free speech. I must be exceedingly careful, prudent as to what I say. Those imprisoned men are simply paying the penalty that all men have paid in all the ages of history for standing erect and for seeking to pave the way to better conditions for mankind." For uttering those words and others such as, "The master class has always declared the wars and the subject class has always fought them," Debs was convicted and sentenced to 10 years in prison. That conviction was affirmed by the United States Supreme Court in an opinion by Justice Oliver Wendell Holmes, Jr., perhaps the greatest jurist of his time. Many others were rounded up and prosecuted under the Federal Espionage Act because of their radical beliefs in opposition to the war. And not to be outdone, half the states passed their own sedition laws. Under Montana's sedition law alone, 79 people were convicted, 41 received prison terms. Those of German descent were particularly vulnerable to prosecution. A traveling wine salesman was sentenced to 7 to 20 years for calling the wartime food regulations a big joke. In 2006, the governor of Montana pardoned all those convicted posthumously. Justice sometimes moves slowly. After the bombing of Pearl Harbor and America's declaration of war against Japan in December 1941, a public wave of hysteria swept the West Coast, and the military commander of that region, General DeWitt, recommended the evacuation of the entire Japanese-American population on the ground of military necessity. By February 1942, President Roosevelt issued an executive order that resulted not only in the removal of 120,000 individuals of Japanese ancestry from California, Oregon, Washington, and Arizona, but also their placement in detention camps. 2/3 of those were American citizens. Although the justifications for the executive order was military necessity, it was the product of fear, racial prejudice, and misinformation. General DeWitt, who as much as anyone was responsible for the mass removals, referred to the Japanese as an enemy race, and said a Jap's a Jap, and recirculated false rumors about planned sabotage as though they were hard facts. One supporter of the evacuation was the California Attorney General, Earl Warren, the future Chief Justice of the United States Supreme Court. In Korematsu versus United States, by a vote of 6-3, the United States Supreme Court upheld the mass evacuation and detention of Japanese Americans who had committed no offense against the United States. Justice Black, best known as a champion of the First Amendment, wrote the opinion for the court. Justice Black acknowledged that although most of the detained were no doubt loyal to the United States, the court could not reject the findings of the military authorities because of, quote, an unascertained number of disloyal members of the group. One of the dissenters, Justice Murphy, who happened to be the former Attorney General under President Roosevelt, characterized the government's actions as, quote, the legalization of racism, and described the mass removal of Japanese Americans from their homes as falling into the ugly abyss of racism. Another dissenter, Justice Jackson, was worried that the legacy of the court was writing into law something very terrible. And he noted that a military commander may overstep the bounds of constitutionality, and it is an incident. But if we review and approve, that passing incident becomes the doctrine of the Constitution. Although those prescient dissenting voices did not prevail, Korematsu today is an opinion that lives in judicial infamy. In the late 1940s and early 1950s, during the so-called McCarthy era, the public was whipped up into a frenzy about the Red Menace, and suspected communists were hounded out of government and blacklisted in private industries, including Hollywood. During this time, the eminent jurist, Learned Hand, expressed his concern that America was entering a new age of witch hunters who would root out heresy and enforce standards of conformity. He feared in America, quote, where each man begins to eye his neighbor as a possible enemy, where denunciation takes the place of evidence, where orthodoxy chokes off freedom of dissent. In that climate, leaders of the American Communist Party were convicted of violations of the Smith Act, which made it a crime to advocate the overthrow of the American government by force or violence. The basis of the convictions was not action, but speech. The defendants' advocacy of the doctrines of Marx, Lenin, and Stalin. At the trial, the federal district court judge instructed the jury that it could find the defendants guilty if they had the intent to overthrow the government by force and violence as speedily as circumstances would permit. That jury instruction hardly met with the traditional First Amendment test that restricted criminal prosecution of speech to cases involving a clear and present danger. Defendant's speech did not pose an imminent threat to the nation's security. Nevertheless, in 1951, in the midst of the Korean War and the ideological war between capitalism and communism, the United States Supreme Court affirmed the convictions of the 11 defendants in the case of Dennis versus the United States. That decision helped fan the already poisonous atmosphere that had overtaken the country. Justice Black, in dissent, lamented in these words, "Public opinion being what it now is, few will protest the conviction of these communist petitioners. There is hope, however, that in calmer times, when present pressures, passions, and fears subside, this or some later court will restore the First Amendment liberties to the high preferred place where they belong in a free society." As with Korematsu, the Dennis decision would later be regarded as a judicial embarrassment. Today we condemn the government's excesses during the First World War, the internment of the Japanese during the Second World War, and the witch hunts of the McCarthy era. However, at the time, too few people spoke up. Why didn't the courts perform the role that Hamilton expected of them, to protect the fundamental rights of those who expressed radical views, or who were just perceived to be different? The answer partly is that judges are not Platonic philosophers. removed from the hurly-burly passions of their time. They are next-door neighbors, members of their communities, and subject to the same fears, misconceptions, and prejudices that grip their fellow citizens. The hysteria that sweeps through every sector of society can also infect the courts. Courts also are understandably loath to second-guess national security claims made by the executive. Courts can do much to preserve freedom, but they cannot do it alone. That is the message, I believe, that Judge Learned Hand tried to convey in remarks that he made to a group of immigrants to whom he administered the oath of citizenship during the Second World War. Hand said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. While it lies there, it needs no constitution, no law, no court to save it." So what is my point? Constitutional rights are more likely to survive the social and political upheavals caused by some national trauma, when those rights find a deep and abiding respect in the public consciousness. Certainly, judges should learn from the mistakes of the past, and they should serve as a reminder of the forces and pressures that need to be resisted in order to keep faith with the Constitution. But judges alone cannot create the climate in which constitutional rights can thrive. All of us have the duty to keep the spirit of liberty alive. I've spoken of times when the Constitution has gone into hibernation. I hope you guys aren't going into hibernation right now. Now I would like to speak of cases when the Constitution has awakened to the fullness of its promise after progressive and enlightened advances in society have paved the way for the recognition of rights that have lain dormant. There is no better example of constitutional redemption than the 1954 United States Supreme Court decision of Brown versus Board of Education, which held that state-mandated separate but equal school facilities for whites and blacks, that is, the enforced segregation of the races, violated the 14th Amendment's guarantee of equal protection of the laws. Today, that decision is taken as an article of faith, but then it was a brave and bold step forward in a country still infested with racial prejudice. Indeed, the decision met with determined resistance in the South, requiring President Eisenhower in 1957 to send federal troops to Little Rock, Arkansas, to enforce the Brown decision. In deciding Brown, the Supreme Court overruled the 1896 precedent, Plessy versus Ferguson, which had upheld a Louisiana law that made it a crime either for a black person to sit in a railway car reserved for whites, or for a white person to sit in a railway car reserved for blacks. The court said that the law was constitutional because the railway provided separate but equal accommodations. In support of that outcome, the Supreme Court in Plessy noted that it was universally recognized that state legislatures could establish separate school systems for white and black school children and forbid the intermarriage of the races. Thus, in 1896, our nation's highest court sanctified the disparate treatment of blacks under state laws. Only Justice John Marshall Harlan dissented, writing, "Our Constitution is colorblind. It neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color, when his civil rights, as guaranteed by the supreme law of the land, are involved." When Plessy was decided, racial prejudice was deeply embedded in the habits and the traditions of the people of this country. and in many places state-sponsored, racial discrimination was a way of life, cruelly enforced, particularly in the South, through Jim Crow laws. Sadly, the majority in Plessy was totally in step with the times. It was Justice Harlan who spoke of a colorblind constitution, who was the visionary, addressing the future, not a society ready to accept the words equal protection of the laws. When the Supreme Court overruled Plessy in 1954 and discarded the doctrine equal, separate but equal, it was not just that different justices were on the court, but that those justices confronted a different world. What had changed between 1896 and 1954? The answer is much. Between those years, there developed a more enlightened understanding of race relations, and the agenda of racial justice had progressed through the democratic and legal processes and changing social mores. For one, a determined civil rights movement had come into being. The NAACP Legal Defense Fund, led by Thurgood Marshall, a later Supreme Court justice, challenged discriminatory laws throughout the South and then won victories before the United States Supreme Court, which ordered the integration of the all-white University of Texas Law School and the all-white University of Oklahoma graduate school program. During the Second World War, whites and blacks fought and died on battlefields in Europe and the Pacific. And later, Harry Truman ordered the integration of the United States Armed Forces. And Jackie Robinson broke the color barrier in professional baseball. Moreover, a more tolerant, progressive attitude took hold in the northern states. For instance, 7 years before the Brown decision, in 1947, the New Jersey Constitution specifically prohibited racial segregation in public schools and stated that freedom from racial discrimination was a civil right. Those social and legal advances paved the way for the Brown decision, which, though resented and violently opposed by some, particularly in the South, found acceptance in the nation. Yes, it took courageous decisions to render the Brown ruling, but a critical mass of popular support made that outcome possible. Just 2 years ago, in the case of Lewis versus Harris, the New Jersey Supreme Court declared that our state constitution guarantees that every statutory right and benefit conferred to heterosexual couples through civil marriage must be made available to committed same-sex couples. 30 years before Lewis, it would have been inconceivable that any court would consider conferring all the statutory rights of marriage on a committed same-sex couple. What changed in New Jersey in 30 years before Lewis? Not the words in our state constitution, but rather the social and legal landscape to which we applied those words. During those years, there developed a better understanding about homosexuality and the right of gays to live and work as equals in our society. Popular culture, through the medium of television and the movies, broke down stereotypes and dealt maturely with the subject of homosexuality. Moreover, through legislation and judicial decisions, this state, step by step, extended protections to gays and lesbians. In 1992, the legislature made it unlawful to discriminate on account of one's sexual orientation. And in 2004, it passed the Domestic Partnership Act, providing same-sex couples with certain rights and benefits that had been conferred to married couples. And on the judicial front, New Jersey courts held that a gay or lesbian could not be denied his or her parental rights, such as custody and visitation rights, or the right to adopt a child. Even the New Jersey Division of Youth and Family Services began placing foster children in the homes of same-sex couples. And in 2003, in the landmark case of Lawrence versus Texas, the United States Supreme Court invalidated on 14th Amendment due process grounds Texas's sodomy statute, finding that Texas could not control the intimate lives of homosexuals by making their private conduct a crime. When we applied the equal protection principles in Lewis versus Harris, the world in which we lived was different from earlier eras that could not have conceived of the notion of gay rights. What can we learn from the Brown and Lewis decisions? As attitudes adjust to a world in transition, the public will become more receptive to the application of constitutional principles to new and unimagined circumstances. Constitutional rights need an enlightened and tolerant environment in which to take root. And the responsibility for fostering that environment falls on all of us, not just the courts. Often constitutional principles evolve in tandem with the changing society. It may be less likely that constitutional principles will change the face of society than that a changed society will accept the novel application of constitutional principles. So what is the final message that I wish to leave with you this evening? However courageous judges may be, however bold, wise, and hardy they may be, on the great issues before us, their way will be made easier when the people of our country are imbued with the spirit of liberty and are firmly committed to the fundamental rights that protect those who are different, those with whom we disagree, and those who are most vulnerable to government oppression. Thank you.
Thank you very much, Justice Alvin, for your wonderful words. We figured that as a Jewish Law Symposium, the best way to bring across the message of the Talmud and what the Talmud is, what the Jewish legal system is to pick a topic that we're all familiar with, democracy, individual rights, and analyze it from two perspectives, the civil law perspective and the Talmudic perspective. We've heard one perspective from an esteemed justice for which we're most grateful for. At this time, I'd like to ask Rabbi Shlomo Yaffe, Dean of the Institute of American and Talmudic Law, to give the Talmudic perspective, the Jewish law perspective of the same topic, democracy and the uncertain fate of individual rights. He will be making reference to some pages at the end of the handbook in front of you on pages 30 and 31 during the course of his lecture. Rabbi Yaffe, please.
Thank you. Thank you, Justice Alpert, very much for your impassioned and erudite words. One of the most important things, I think, that we can do when comparing legal systems, in particular systems that are in many ways very different, in many ways very similar, such as the particular constitutional system which has its roots in the very diversity of class, of nuance, of intellect, of background that comprised this republic on its founding. The very diversity created many of the salient features of the system that you heard about just now. And conversely, the Judaic system is based on a common goal, on a common eternal kind of concept, on a homogeneity. There's all these jokes about 2 Jews and 3 opinions, but that in itself is a characteristic that all Jews share. And you're dealing with a legal system designed in many ways to express and to strengthen the unity and the singular journey along a very well-defined road to a vision of where a society needs to be. I mean, if you take a look, even though there's obviously the earlier writers who like Locke and Paine and the like, who were deeply and their predecessors, we can go all the way back to the natural law writers of the 16th century. But if you look at all the people intellectually, all the intellectual streams that flowed into that very, very unique and wonderful group of people who gave us our Constitution and our system. And not only that, somehow made a system that worked. Simon Bolivar wrote several beautiful constitutions for the new South American countries. But the system wasn't there. In many ways, barring a few articles that negate the whole thing, but in many ways, the Soviet Constitution, promulgated in the early 20s, and all the more so the revision that took place in the mid-30s, represent one of the most far-reaching and most liberal documents in human history. The reality of the Gulag was something different. So if you take a look at what took place in this country, essentially you saw an agreement that given the diversity of opinion and of background, the most important thing was in essence process. In other words, and the best person, the one who expresses it best is I think John Stuart Mill on liberty, that if everyone, I'm paraphrasing, but that if everyone gets to say and express and feel what they want to, no matter how erroneous or how ridiculous or how upsetting it may be, if there is an absolute freedom of thought and expression, and that those rights to those freedoms are protected, somehow society will move along by virtue of hopefully the people choosing the best ideas out of this free marketplace of ideas, but it'll move along in a positive way. And we don't know what the destination is, but it seems the process, the journey works best in the context of this type of ethos, which you heard from Justice Albin, and which is the essential American ethos. Now let's take a look at Jewish law. If you take a look at Jewish law, the destination is quite clear. Rabbi Saadia Gaon, the first Jewish philosopher. Jewish philosophy exists from the words in the beginning of creation in the Bible, but the first systematic exposition of Jewish thought in the format of a philosophical book was created by Rabbi Saadia Gaon in the 8th century. He also was one of the great links in the chain of Jewish jurisprudence. Rabbi Saadia Gaon asks an interesting question in this philosophical tract, in the Book of Beliefs and Opinions. He asks, why is it that we have such specific discussions in the Torah of matters like the penalties for stealing livestock, the structure of courts, the financial regulation of marriage, the laws of contracts, the laws of torts, the laws of criminal penalty, and the like. After all, every one of these laws are laws that every human society desperately needs to function at any level. There exists no society that does not have such laws. Surely, God could have left it to us to figure out those laws as we see fit for the societies we live in. In other words, when it comes to the great spiritual values, when it comes to the holidays, when it comes to fundamental ethical behaviors and the like, we can understand that given people's short-sightedness, and given human beings' propensities for selfishness and for a stratification as well as fragmentation one from the other, so these laws, both between the human and God and the human and human, are necessary. But there is so much of the civil society in the Torah. Why deal with it? The civil society will develop itself as it needs to, and we'll figure out how to deal with criminals, and we'll figure out how to deal with property in a marriage, and we'll figure out when and how contracts are binding. Why is it in the Torah? The Reb Saadia Gaon responds with a response which speaks to the essence of all of Jewish law, and frankly, in how it is different from our system, and at the same time, in that kernel lies what it can teach our system. He says that if you look at it honestly, and by the way, I have to say that Reb Saadia Gaon's approach is very much informed by the very nature of the Talmud. We have a little introduction. There are people here who are, I'm sure, more familiar with the Talmud than me, but the Talmud essentially expresses in itself the type of diversity of opinion that Reb Saadia Gaon is going to speak about now. And then he adds a caveat. Reb Saadia says, listen people, if you look at any issue, how strictly to punish criminals, how binding should contracts that are maybe only verbal be, how should we deal with questions of long-term property ownership, with questions of dealing with poverty, the regulation of marriage and families, issues pertaining to the structure as if it were of the state, the rights of the monarch and his prerogatives, and so on and so forth. About these issues, he says, intelligent people have argued well for thousands of years. Every issue, you want to talk about criminal law, you want to talk about the nature of marriage, you want to talk about the ideal structure of the state, you want to talk about the laws of war, you want to talk about the regulation of contracts and torts. Intelligent men and women throughout history have argued these issues. And therefore, he says, it is no human being can honestly stand up and say that I know that if today I promulgate a law of torts as such, what the results will be as the society evolves 1,000 years hence. Will it be good? Will it be bad? Will there be a better way of doing it? After all, many of the reforms and torts that changed the master-servant relationship, that in the 1880s, 90s, and 1910s completely transformed the landscape of torts and allowed, for example, a passenger injured in a railway accident, both in the United Kingdom and this country, to sue the railway company, which did not exist in the early 19th century. That was seen as a great advance. And now, there are many people in society, and they're in many professions, including the medical profession, who are yelling that this has gone way too far and we cannot bear this burden. Where will the truth ultimately lie? What will be the best for society? Who knows? So Reb Saadia Gaon is saying no one can ever really tell you. No one can ever really tell you how it's going to work out 1,000 years down the road. Except one. If you accept the core premise of Jewish law, which is that it is the vision, I should add from another great rabbi and jurist, this time a late 19th century German one, Rabbi Shamshon Raphael Hirsch, once said that Judaism is not a religion. Because a religion is a human conception of God. And Judaism is God's conception of how people should act. Judaism is very much about law, which is, it's not coincidental that there is a disproportionate number of Jewish jurists out there. It's in the very essence of Judaism. And that being said, the concept is, and now going back to Reb Saadia Gaon, the concept is, he says, that after all is said and done, we believe that Jewish law and its fundamental roots and the ways detailed in the little outline you have here at the beginning of this handout has its roots in the divine. In other words, that the Torah represents a manual by the designer of humanity and the universe as to how humanity as a whole, we'll get to that later, and a particular group within humanity, how they can best reach their ultimate potential. So says Reb Saadia Gaon, no human being can tell you what system of tort law will most work with a thousand years hence with all the possible advances, technological and otherwise, that may exist. And I'm sure Reb Saadia did not conceive of the technology of the 21st century. But he said, what I do know is that no one can guess what will work best. Only that being who created the human being and created the human mind and created and designed the propensity of those minds to coalesce and form societal units. Only he can know. Only God can possibly know what is the best possible way to regulate the law of torts 2,000 years in the future. And therefore the Torah deals with all these things. Now, to be fair, the Torah is a partnership between God and humanity. God laid out certain principles in the Torah. God laid out certain systems of interpretation. The rest God left up to us. There is an absolute concept of partnership. It's right at the beginning of Genesis. It says that God saw all that He made, and He was pleased, etc., etc. But shabar Elokim la'asot. Everything that God made, la'asot. So say the commentaries, it doesn't mean that which God created to make, which is what the Hebrew word seems to mean, but la'asot also means to finish. God created an incomplete world and said, hey people, you finish it. You finish it with your work, with your ingenuity, with your mind, with your ethics, and with the principles I've given you to finish, as if it were, or to extract what my Torah has to say. So therefore, the vision of Judaism is a vision of the ideal destination of society, and the question is, how do we get there? The question is, given the fact that the Torah gives us room to interpret and understand, how do we get to that destination? And that is all of rabbinic law revolves around the ethics found in the Torah. Every rabbinical decree, every development of Jewish law has as its basis the ethics, the vision of the ideal society that the Torah, and very important in terms of the vision of how the society should look, what the laws should look like, the prophets. As we know, the prophets add nothing to the 5 books of Moses in practice, but they reveal to us what a world that lives with the Torah should look like. So now you have this vision. What I think is really useful, the founding fathers and all the courts and all the legislatures and all the other all the branches of state government and the like, that throughout the years have developed this legal world we have in this country, make no such claims. However, there is a common point over here. And the common point is that since the vision the Torah has is of equity and treatment, the vision the Torah has is of judging everyone equally, since the vision the Torah has is of not being swayed, as we'll see in a moment, by the passions of the powerful or of the mob, not being swayed by misplaced sympathy. Since the values, the process values the Torah expresses, are values that our society would applaud, more than that, I would go very far in a limb. And I would say that in truth, if you look at the original documents and you look at the lives and the writings of the people who founded this country, at least legally speaking, you will discover that though they felt very strongly, many of them, that there is no way that human beings can arrive at an absolute truth. The values they saw, the vision they saw, was very much the vision that is articulated in the Torah, that is articulated in the prophets. And what I want to do today is, in the few minutes I have, is to go through some of these statements of the Talmud, which deal with the issue that was brought out so succinctly and beautifully by Justice Albin, the fact of the gap that exists between the ideal vision of the Constitution and of our laws, and what happens because of the nature of whether the opinions of the popular or the powerful. So I want to look at this issue, because this is really the greatest issue when you're dealing with individual rights. Because you know what? Look at the Soviet Constitution. All the laws in the world aren't going to help you if there isn't a fundamental belief and premise to uphold it. And, of course, since in the Judaic system there's no division between religious and civil law. In other words, every law, as the Talmud says, let a case about a penny be as important to you as a case about 1,000,000 gold pieces. The Talmud says that ultimately all of law is a simple question. Am I being a good steward to society? Am I guiding society in the vision of the perfection of the potential of the human being that God gave us? And because even the most basic civil litigation is a profound moral, ethical, and most of all religious truth, the concept of not being swayed, the concept of strength of conviction, as we'll see in a moment, the concept of educating the masses that they should not be driven by blind passions, is the very essence of what Jewish law sees as the core of the vitality of its system. And I humbly suggest that this is an intersecting point, that this is a point that our system can draw from also. So let's turn to page 30. Now, the verse from Exodus that I'm going to quote here, legally, this verse has another meaning, which is highly technical. It's very interesting. It's about the death penalty. I'm sure you'll have a chance to study it with Rabbi Lubin. But Rashi here says that the plain meaning of the text makes an ethical point, which is an overarching point. It is a transcendent point that drives all the interplanetary gears of the system, as if it were. You shall not follow the majority for evil. You shall not respond concerning a lawsuit to follow many to pervert justice. You shall not follow the majority for evil. If you see wicked people perverting justice, do not say, since there are many, I will follow them. Maimonides explains, actually, brings this down for law, that if you're part of a court, you cannot hide and say, well, I was part of the court. Now, the truth is that one must follow the majority ruling. But if you see there's something dishonest going on, as opposed to an opinion you don't like, in which case you're supposed to accept the majority ruling and swallow your opinion, and uphold the law as it's established. When you see there is dishonesty, you see there is venality, you see there is cowardice over here, you have an obligation to recuse yourself, to walk away from the court and say, I will have no part in this. Famous story. The famous story told of King Yanai, where he walked into the court. He walked into the court to support a servant of his who was suspected of murder, and said, "Will you judge this man?" And it says all the members of the Sanhedrin of the High Court stuck their faces in the ground. And Reb Shimon ben Shattach, who we're going to meet in a moment in another context, warned them and said the Torah commands us to fear no one, and the moment that you do this, you ultimately will fall into the hands of exactly that which you didn't fight against. And in the end, King Yanai killed all the members of Sanhedrin. Shimon ben Shattach escaped. It goes on to say, and you shall not respond concerning a lawsuit to follow. If the litigant asks you about that corrupted judgment, not answering concerning the lawsuit with an answer that follows those many to pervert the judgment for its true ruling. But tell the judgment as it is, and let the neck iron hang on the neck of the many. In other words, don't support a judgment that you know is corrupted. Don't support the system where you know it's wrong. Again, in a Sanhedrin, you must obey the majority. But if you see that it's corrupted, pick yourself up and walk away. And don't support and never say, I will support the system, I will support the institution against the Torah it is asked to uphold. Never support an institution against the values it's meant to uphold. Neither shall you go, and by the way, this has happened in history. The Talmud relates that the Sanhedrin under King Saul's advisor Achitophel not only was it the institution that pursued the later to be King David, pursued David almost to death, but when inadvertently the priests of Nob gave him shelter at the instigation of this corrupt leader of the Sanhedrin. The members of the Sanhedrin became a vehicle for the executive rather than a check upon it, and slaughtered the priests of Nob. And this is quoted constantly in the Talmud as a cautionary tale. Now, let's talk about the passions of the majority. Let's talk about what the people think. There are lynch mobs, and then there are things that we do legally to satisfy the desires and the feelings of the masses that may not be legally true. And again, Judaism does believe in an absolute legal truth. In other words, what the Torah tells us, the law, is an absolute truth, and even if every single person in the country disagrees, that makes no difference. And again, we don't have the same absoluteness in our system, but I think it's fair to say that the whole idea of the Bill of Rights was that it represents ideas that are supposed to be bigger than the passions of any given moment. So, may I never see comfort. Reb Shimon ben Shattach said, may I never see comfort. It's a kind of oath. If I do not see a man pursuing his fellow into a ruin. I ran after him and saw him sword in hand with blood dripping from it, and the murdered man writhing in his death throes. I exclaimed to him, wicked man, who slew this man? It was either you or I, and we know Reb Shimon didn't do it. But what can I do, since your blood does not rest in my hands? For it's written that the Torah, the mouth of two witnesses, shall he that is die be put to death. May he should be capitalized, who knows one's thought, exact vengeance from him who slew his fellow. He says, look, everything tells me that you're a murderer and should be put to death. Anyone hearing the story, anyone seeing the story would be shocked, upset, angry that this man escapes. He says, no. It doesn't make any sense to me either. I know you're the murderer. It makes no sense to me. But the Torah says there's a system, there's a rule, and there are witnesses, and there are obligations, and this is God's issue, this is not mine. Now, Reb Shimon ben Shattach had a simple justice we often don't see. It is related before they moved from the place. A serpent came and bit him, the murderer, so that he died. We don't often get such vindication. But then not all of us are Reb Shimon ben Shattach either. But the point is that this story is there in the Talmud, and the commentaries make the point. This isn't just about his story. It's about what any reasonable person would think. It's about, it is the type of court decision, though in this case it was Reb Shimon ben Shattach saying, we don't have a case here, that causes people to rise to the barricades and yell about the evils of technicalities. How often do we hear that? You know what? No human being, the morale of Prague, great 16th, early 17th century rabbi, jurist, philosopher, one of these figures who does everything, sort of the next one down from Maimonides, the next generation. And the morale of Prague, Rabbi Yehuda Levoi says that no human being ever attains complete justice. It's not possible. We simply have to do that justice that God puts in our hands and not step over the bounds and imagine that we can get to complete justice, because only God can get there. Now, this is something I think every attorney, but I think in particular every judge and prosecutor, and probably public defender, should bear in mind. Ketubah 105, Abaye said, if a scholar is loved by the townspeople, their love is not... Now remember, here's the thing. A scholar, the rabbis of the Talmud, to this day, but certainly when in the Talmudic period and even into the right through the early modern period, when Jewish societies were autonomously governed, which was true both in the Sephardic and Ashkenazic lands, the scholar, the rabbi, his primary role was as a jurist. Abaye said, if a scholar is loved by the townspeople, their love is not due to superiority, but to the fact that he's not rebuked them for neglecting spiritual matters. Spiritual matters is matters of justice in weights and measures as much as it is about attending synagogue. It's equal things. In other words, if you're a rabbi, if you're a judge, if you're in a position of moral authority and you're really well loved, and no one is complaining about your authority, it's probably because you're not pushing them, you're not demanding them, you're not challenging them, you're not telling them where their opinions may seem right to them, but are wrong according to the law. And then Rabbah says, before we get too upset about this, Rabbah says, at first I thought, Rabbah was the rabbi, the chief rabbi, and the head of the rabbinic court of the town of Mechuzah, which is not far from any of the towns that are in the news very often. It's actually, I actually believe it's pretty near one of the corners of what's called the Sunni Triangle. Rabbah said, at first I thought the people of Mechuzah loved me. When I was appointed judge, I thought that some would hate me and others would love me. Having observed, however, the man who loses today wins tomorrow, I came to the conclusion if I'm loved, they all love me when they win. And if I'm hated, they all hate me when they lose. And therefore, I shouldn't pay attention to what the people feel or think about my decisions. I need to make those decisions in accordance with the vision of the law and try to bring and educate and guide the people that they see that vision too. The next few pieces deal with the issue of not allowing one to be swayed. And the love and approbation of the people is very much a source of sway. So for example, a rabbi's taught you shall take no gift, so there's no need to speak of a gift of money, that's called bribery, but even a bribe of words, which really means a subtle bribe, is the bribe offered to Samuel. That's the last paragraph on page 30. He was once crossing a river on a board when a man came up and offered him his hand. Shmuel says, oh, what are you doing here? He says, I have a lawsuit. He says, you know what, I'm disqualified from acting the lawsuit. I think favorably of you now, and I don't know the other guy in the lawsuit. And this is equally true of public opinion. Now, however, it is really, now we have, in best Jewish fashion, we're going to conclude with a question and answer. The question is one that was raised by our earliers. After all is said and done, people are driven by the societies they live in. And it's very hard for them, for most people, to escape the assumptions of that society. Says Maimonides, the law of character, yes. Because Judaism is all about law. Maimonides has this magnificent piece in his first book about, we just began, there's this yearly cycle of the study of Maimonides' Mishnah Torah, his magnum opus, which in 14 relatively short books includes all of Jewish law. An amazing, amazing work. And the Lubavitcher Rebbe instituted a practice that has spread to many reaches of the Jewish people to study this book every year. And we just started again. We're going to get up to these laws soon. And the laws of character are amazing because basically it talks about the ideal character, the kind of character that the Greek philosophers suggested that only a few people in a generation can reach. And Maimonides says these are laws and every one of us can get there, and tells us how to get there. And just amazing, amazing piece of work. And one of the things he says is the nature of man is to be pulled by his temperaments and actions after his milieu, to accustom himself to the customs of his locale. Page 31, therefore one is to associate with righteous people and sit amongst learned people so that one will learn from their actions. As Solomon says, he walks with wise men shall be wise, but a companion of fools shall suffer harm. So it goes on to say that if you heard about every country has bad customs, so go live in the wilderness. But, don't hang around with people whose character is bad, where the mass holds unacceptable things, acceptable being defined by the vision of character in the Torah and the prophets. So the question, of course, is, if people are perforce driven by the nature of their society, how do we get people away from their negative prejudices? Not all prejudices are negative, but how do we get people away from the negative prejudices? How do we get people away from their selfish, short-sighted, and venal vision? And the answer lies in the fact, in the next statement, which is also from Maimonides, which is that to Judaism, the law, which includes both its application and its ethics, are not for jurists, and not for philosophers, and not for professors, and not for people in government. The law, in all its intricacy and glory, in all its ethical underpinnings, spiritual sources, and practical applications, belongs to everyone. From the point of view of Judaism, every Jew needs to know the law. Because if you end up in court, you failed. Someone's broken the law. Everyone needs to know the law and live it. Everyone needs to know as much of the intricacy of law as possible. Because that one lives and breathes the law, because this is the way that one lives and breathes the divine vision for the human potential. And therefore we say, not every lawyer, but every Jew is obligated to learn Torah. Whether he's rich or poor, physically complete or disabled, whether he's young or an old person of failing strength. Of the great number 9, of the great sages of Israel, some were woodcutters, others were water fetchers, others were blind. Even so, they learned Torah by day and night. They were of the people who received from the chain of scholars going back to Moses and passed on the legal traditions. Because the Torah is truly democratic. It belongs to everyone. Now, what one must know. One is also obligated to divide one's learning time into 3. A third for learning the written Torah, a third for learning the oral Torah, and a third from which to understand and comprehend what one learned in the first 2/3 by deriving facts from other facts. In other words, looking at precedent and deriving from precedent, using the 13 principles of Rabbi Yishmael that interpret the Torah. And this type of learning, he concludes, is the Talmud. In other words, as if it were, the Talmud is basically a collection of discussions that took place in the academies and in the courtrooms and so on. It's as if we said that every single citizen in this country should be knowledgeable in the Constitution, its debates, and jurisprudence. That every high school kid should understand the Federalist Papers. And I actually believe that that's the case. I may be revealing my inclinations, but that's okay. After all, Adams and Jefferson made up in the end, did they not? But, and he goes on to say, how is the division of time done? If one in a profession worked out for 3 hours a day, I know all the lawyers would love this, and one learned Torah for 9 hours, then those 9 hours, you learn the written Torah for 3, and so on. He goes through, he divides it up. Goes on to say, esoteric philosophy is part of the Talmud. The underlying ideas and themes, because without the underlying ideas and themes, you get stuck in a pedantic vision. You need to know how to apply the law to new situations. You know, when all the ethicists were sort of stumbling, what do we do with cloning? What do we do with stem cell research and the like? The Talmudists were on it very quickly and formulated a complete and pretty strong consensus pretty quickly, because the whole Talmudic system and its philosophical underpinnings are designed to be able to strip away the question of which garment are we wearing today and get to the essence. Technology, social change, those are all garments. The question is, what is the essence? So Maimonides says, are societies driven by what people in them believe? Yes. Therefore, the society must be educated. And not educated in their narrow fields, the woodcutter, the water fetcher. In moral philosophy, for a Jewish society, the Torah, its values, its underlying philosophy. Now, as we know, much of the Torah is universal. The Torah is given to the Jewish people with regards to its 613 commandments, but the Torah, before the Jewish people come on the scene, and throughout the prophets, speaks of a universal vision for all of humanity. That vision is enclosed in what Maimonides and the Talmud call the Noahide laws, but these 7 laws actually comprise probably several hundred, really, of the laws in the Torah. And they basically deal with all the moral, ethical, national kind of laws. So I would suggest and that's where the staying, by the way, comes in the Talmud, that a non-Jew who is well-versed in Torah is far advanced beyond a high priest who is ignorant. what does the non-Jew need to know about the laws of kashrut farther than curiosity? The answer is because a lot of Torah isn't about the particular religious laws of the Jew, but about the universal that applies to all of humanity and that the prophets envision all of the humanity uniting in, hopefully at some point that isn't too far in the future. So, from a universal perspective, the laws, its belief, its underpinnings, its vision, its universality is something everyone needs to know. So I'm just going to conclude by saying that in the context of this society, what can Judaism, what can Jewish law teach this society? Quite simply, that we need to do a much, much better job of educating the members of this society what our core values are, that they should indeed understand the background to the Constitution, understand what it's trying to accomplish, understand the cautionary tales of what happens when we deviate and leave that behind, as a case like Plessy did. And that this should be more mandatory, this should be as mandatory as knowing something like algebra, which I can promise you that 98% of Americans never use the algebra 2 and calculus they learned in high school. We should have lots of great scientists, but 2% is enough for great scientists. And you know what? The fact is that the knowledge of what our Constitution is, the knowledge of what the underlying values, which I believe the underlying values you see of the Constitution and the writings of the founders are very much these universal values that are espoused in the Noahide laws, which is another subject. But these values need to be learned, they need to be understood, they need to be argued, and if you know your geometry, all the more so, every single child should walk out of high school understanding what the underlying values. Then we won't have an ignorant society, and we won't have those passions and prejudices and short-sightedness driving our legal system and our government, etc., in directions that, in the long run, are not to its benefit. And with that, I will leave you. And I think that in the differences at the points of intersection of these very differing systems, there is a great deal that can be learned, and a great deal that the elder legal system, the system of the Torah and the Talmud, can speak to this slightly younger, but very vibrant, and I think system that has a lot of hope and a lot of future and a lot of good things to come in our country. Thank you.
Thank you very much, Rabbi Yaffe. If anyone has any questions written down, you can please pass them forward at this time. Mr. Harold Graff will be the moderator. You could just turn the microphone on for the questions. I also encourage everyone to fill out the survey forms on the tables and leave them on the tables. We'll look at them after. If I could have your attention for one more moment, I would just like to present, before we go to questions, Justice Albin with a plaque thanking him for his participation in this program. I'd like to ask, if possible, Chief Justices to come up with a presentation and a photo op, and then we'll move on to the questions. Please pass them up at this time. Thank you. The piece of art says, rightfully so, Tzedek, Tzedek, Tirdof, the words from the Bible that say, justice, only justice shalt thou pursue, presented to the Honorable Justice Barry T. Albin, Justice of the New Jersey Supreme Court, in appreciation of your participation at the second annual Jewish Law Symposium, Chabad of Southeast Morris County, Rabbi Shalom Lubin, Executive Director, June 17, 2008. It's truly an honor and privilege to have you at the symposium, and we thank you very, very much.
That comes from the southern side of Cuba. What is your reaction to the United States Supreme Court ruling that will give people who have been held at Guantanamo Bay the right to speak to a federal judge? Now, these people have never been charged with any crime against the United States. Of course, I doubt if there's anybody in the room who wasn't thinking about that as you spoke.
Well, I always accept the majority rulings of the United States Supreme Court. The case is the Bumi Yen case. I found it very interesting. It really told me a lot about the greatness of this country. When you think that the detainees in Guantanamo are not American citizens, and there are several hundred of them, and if the United States Supreme Court would issue a ruling extending the writ of habeas corpus to the most disfavored of groups that one could imagine, I think it said something quite spectacular about the goodness of our law and the power of our Constitution. What's really at stake over here? And what sort of threat does this pose to the country? That someone who is detained for more than 6 years might have the right to go to a federal district court and present evidence that perhaps he was mistakenly picked up on the battlefield. That's what the case is all about. So, you know, it was a 5-4 decision. It shows that these issues are being decided by the smallest margin imaginable. But, you know, there it is. It's now the law of the land, and you know, those people have an opportunity to go before a United States federal district court judge, and if there's evidence to show that they mistakenly picked up, present that evidence.
I have another one for you, Justice. How is the social climate leading to the Lewis case and the court following any different in Korematsu reaction to the times, other than that you can agree with one and not with the other?
Well, how is the social climate different from like 1942 after Pearl Harbor was bombed and the American public, particularly on the West Coast, was fearing perhaps an invasion of Japanese troops, compared to the social climate in New Jersey in 2006 in terms of being willing to accept the notion of equal rights for gays and lesbians? I think we're talking about a universe of difference. In 1942, there was literally a wave of hysteria that had swept the West Coast and many other parts of the country. So, something that is interesting, you know, I told you about the hysteria, I told you about the executive order, but there were people, even in 1942, in the American government who thought it was wrong and who were actually fighting against that executive order. The Attorney General himself, Francis Biddle, the Secretary of War, Henry Stimson, they knew that something was wrong about that, but they just weren't able to overcome the pressures, the claims of military necessity, the words of General DeWitt and others who were saying that there was planned sabotage. I don't even know that we can compare the situation in 1942 to 2006. If a person did a poll of the New Jersey society in 2006, I think that many would have warmly embraced the idea of giving equal rights to same-sex couples. And that is because this state is one of the most tolerant, diverse, and possesses some of the best people in the country. Now, you could go to another state in the middle of the country, and the attitudes, the views, the values, the customs are completely different. When we talk about the red map and the blue map, there are different attitudes throughout the country, and therefore what might be acceptable in New Jersey in 2006 may be completely alien in some other state. So the decision that we rendered in 2006 was able to take root because of the tolerance, the open-mindedness, diversity of the state. I don't think it was really sort of a big move for the people of the state, and in gauging the reaction, it seemed that the people were accepting of the decision.
Thank you.
I want to run a lecture series on the topic and so on, but this is the Torah's view, and
Wednesday at 12 o'clock.
Whereas at the same time, I should point out that it is deeds that the Torah looks at, and that's even on an internal and personal level, and that no one is ever punished for their inclinations. More than that, those who have inclinations that make their observance of the Torah difficult are all the more praiseworthy for their observance of the Torah. And that is the honest, unsugar-coated truth, which is, I understand, not necessarily the majority opinion in New Jersey, but so be it. As we just got through saying, one must stick with what one believes and certainly with what one understands the Torah is saying, irrespective of whether it is popular or not, or whether people are happy with it or not. As far as which one to obey, that is a far more complicated issue, because there's a basic obligation to treat every human being decently. There is also an obligation to punish criminals, to wage war aggressively and with the end of ultimate victory. It's another whole subject, the laws of war in Judaism. And that saving life transcends everything. In other words, hypothetically speaking, if I had a case where I think that that issuing a writ of habeas corpus would demand that the government reveal something that it is dangerous to life for it to reveal, or I may not be able to satisfy the federal judge, but I, in my military capacity, am satisfied that if this man leaves detention, they will be responsible for the deaths of innocents. I think Jewish law would rely on that military judgment in this case in a time of war. That is because the slightest chance of danger to life outweighs many things. It's one of the unique characteristics of Jewish law that even a small chance of danger to life outweighs all other rights and all other concerns. So, by that same token, Jewish law strongly not just recommends, but commands preemptive strikes against those who desire your harm. The classic formulation is, he who comes to murder you will rise and kill him first. And this may not be so different from the doctrines of just war as understood by many jurists today, but nevertheless, as far as this issue of detention, one thing I will say on the side of the Supreme Court's decision, that I don't think that there is a distinction between one category of criminal suspect and another vis-a-vis their rights in court. I don't think there should be such a distinction. But I think that if there is a sound military judgment on the part of a democratic military, in other words, a military that we trust to carry out our laws and the like, that this person may endanger either American soldiers in the field or innocents by virtue of terrorism, and they feel that that information matches the standard of military necessity and operations, but maybe not that of a law designed for the domestic criminal, as if it were habeas corpus is practiced by federal judges who are dealing with the ordinary run of criminal in this country. So maybe I'm not so sure about the decision. So I don't know, but here's my this is my Talmudic I don't know.
The Talmud address that?
Well, I mean, the principle of have no fear, the principle that witnesses must always testify, and they may not fear, because without fearlessness of retribution, the criminals and gangsters control the world, which is what Shimon ben Shattach told his fellows on the Sanhedrin. If you let the king intimidate you, you will ultimately be destroyed by the system. That being said, at the same time, we have an obligation to quote Maimonides. Maimonides talking about the king, the executive branch as if for Judaism, that it is his job, l'shaber yad mishayolam, to break the might of the wicked people of the world, which means to say that the criminal element should not feel free to intimidate, to harm, to attack. In other words, on one hand, so therefore our goal has to be to educate people that the most important civic duty that literally is worth putting your life on the line for is to stand up for what is right, to prevent people from the destruction of others. But conversely, our obligation, which I think very often our overworked courts and police departments fall short on, based on the stories I have heard, situations I've dealt with and so on, we need to do a much better job of showing that we protect these people and that we value these people as the only people who will ever break the horrible cycles that take place in our inner cities. We have to applaud their courage, but back it up with steel.
Just to add one point to that question, specifically when it comes to people sensitive to Jewish law and Talmudic law, there seems to be quite often a resistance. I hear this from criminal attorneys all the time, to turn someone into the criminal system. There's a hesitation from the Talmudic law and civil law not always working on the same page. And if you could address that specific issue, please.
That actually is another whole topic. On the whole, a Jew is not supposed to inform. This is very explicit in Judaic law. Inform the authorities as to the behavior that brings criminal liabilities with it. The problem is that this law emerges from a period, quite frankly, in which the non-Jewish majorities in which Jews lived invariably across the board, Christian, Muslim, you name it, across the board discriminated against and constantly abused the system of the law, as happened throughout Jewish history, to seize people's property, to harm their persons, to bring opprobrium and destruction upon the Jewish community. First of all, one doesn't unlearn several thousand years of history all that quickly. But secondly, there is a difference when you're dealing with a system which is not functioning with, shall we say, that bias. I can only say, and this question is complicated, and there are those who will disagree with me on both sides of it, let me simply say that it's very clear that all the rabbinic authorities that I know of, when dealing with actual criminality, in particular issues of child abuse, issues of domestic violence, issues of violent crime, robbery and the like, all the kinds of things that we don't have the power within our rabbinic courts to deal with. On the whole, when these questions have come up and I have dealt with them, the rabbinic authorities across the board, and we're talking, I hate labels, but the ultra-Orthodox have all said that it is absolutely necessary to have the authorities and the legal system deal with these people, because we have no means and method of dealing with them, and we are not concerned that this is merely a ploy to destroy the life, limb, or property of a Jew because they're a Jew. And I have dealt with several cases. I can say this is the case, but again, one should understand, being completely fair and honest and brutally so about it, one does not unlearn the fears of many thousands of years, especially if you're steeped in that tradition and you know your history and you know your family history. But in the cases where it really makes a societal difference, I have seen a complete willingness on the part of rabbinic authorities to say, look, this has to be moved into the courts. Thank you.
Thank you, Justice. No, I do have a rebuttal question for you. I'm going to ask you to take on the Talmud.
Tough question.
This question reads, interesting. We are a nation of laws and not, I'm going to change the word to persons. Yet you describe a court that flows with the wind. Isn't the Talmudic rigidity more fair? Well, I think the question is, what do we do about a society that shifts as it does?
Well, the words don't shift. It's the people shift. Depending upon the times and whether or not you're talking about the rule of mob, whether or not you're dealing with the Torah, whether or not you're dealing with the Constitution, if people are unwilling to abide with the words of the law, then they just will not be fulfilled. It makes no difference whether it's the Bible or the Constitution. I'm not talking about the courts from day to day shifting with the winds they don't. I was giving examples in my discussion, and hopefully they're rare examples, when the country is presented with a national crisis, and people are fearful for their existence and for the nation's existence. And they're driven by fear, and sometimes by misinformation, and people aren't being reflective, and they're not remembering the values that Hamilton spoke about, because it's difficult to be philosophic when your life's in danger. So I'm dealing with rare, unique circumstances, but they can happen again, and that's one of the reasons why I chose this topic. You know, we're living in a very unusual time. You know, we've already gone through a national trauma on September 11th, and we're very fortunate to have been spared anything so far, but we don't know what the future holds, and we have to keep in mind history, the values of the Constitution, and the mistakes that we've made in the past.
There are times in our history, and it takes quite a while for it to happen, when we are able to change a culture. The culture of outing, culture that involves so much crime in our society. 97 murders in the city of Newark last year, and that's less than the year before. How do we go about the process of changing a culture? How do we go about changing the culture of the lack of fear, the amount of fear that people have to participate in the system?
Well, if I knew the answer for that, I'd
I wish
be
you would.
running for president of the United States. I wouldn't be on the New Jersey Supreme Court. Well, there's a lot that goes into it. Things that occurred even hundreds of years ago. The legacy of slavery and discrimination, I think, has followed us even to the present day. We're talking about people who are trapped in urban decay, in slums, living in tumble-down tenements with drug pushers and not very good role models. I think it requires almost a Marshall Plan for our urban areas, and it really would require the commitment of the country. I mean, we did this to rebuild Europe. One would hope that some would be able to mobilize, you know, the goodness of the American people and use all of those energies and all of our wealth to bring the people up from our urban centers and do something for them.
Thank you.
Justice Alvin, while you're up there, if we could just, Rabbi Yaffe presented Talmudic law. For many of us, it was the first presentation of the Talmud and its relevance to any legal issue. If we could just get some comments of yours into the presentation on the Talmud, its perspective, and any thoughts you had, I think would be of interest to the crowd.
Well, actually, I wanted to comment on Rabbi Yaffe's discussion of the Boumediene case, but I found that interesting. And I was thinking of extending the writ of habeas corpus to some of the people who are detained in Guantanamo, maybe, I don't know, maybe mistakenly. And I was thinking about the criminal processes that we apply to the citizens of the United States. We have presumptions of innocence, burdens placed upon the state to prove guilt beyond a reasonable doubt. We have privileges that we don't permit or cannot compel a person accused of a crime to give testimony against himself. All of those procedural protections that apply to people accused of crimes in the United States may make it more likely that a guilty person would go free, but we believe in those processes nonetheless. The rabbi gave the example of, I think it was a member of the Sanhedrin who came upon a person who had dripping blood with his sword, and he knew almost beyond a reasonable doubt of the person's guilt, far beyond a reasonable doubt, but let him go, even though maybe that person might kill again at some point. And yet he followed the law because the law mandated that he do so. So there are no certainties in the society. In our criminal system, even even with the extension of the writ of habeas corpus, human beings will make mistakes. I think it may be in the opinion itself, the dissenting opinion of Justice Scalia. The military authorities have released at least 30 people who were detained at Guantanamo, who went on to commit acts of violence in Iraq. So they obviously don't have 100% clairvoyance as to what will happen in the future. I don't want to get into the political matters. I mean, the opinion now is what it is. The dissent says what it says. So, what's next?
Rabbi Yaffe, if we could just conclude the presentation with your response. Words from Justice Allen.
Well, look, I mean, as far as the issue you raised, they say it's complex. The story of Shimon Shetach tells us that you can't criminally convict someone. There's a difference between them. Talmud's very clear between, and Maimonides puts it beautifully, that all these protections apply after someone has committed a crime. But if you're trying to stop someone from harming someone, different rules apply. And basically you have to work with the assumption of doing everything you can to protect life. Does that change the law? Does that change the need for habeas corpus? Does it change my opinion of the Supreme Court decision? You know what, I haven't read it yet. I can't tell you. And I can't tell you because I haven't done the research, to line things up, and some things are not lineable up. So you quoted the Talmud effectively to a good purpose. And this is something that we'll be studying, and we'll see where it goes. But I really wanted to respond to the issue pertaining to the inner cities, because I think there's sort of a missing element here, and this is something that we finally have from the African American community, a presidential candidate, which is a huge accomplishment. Remember, we're only as far from Brown as Brown was from Pleasant. So we've come a long way. But I should say some observations that one of the things I do is I'm the Jewish chaplain for all 4 Jews in the Hartford Fire Department. But like in the military, the job is much less onerous. The chaplains, essentially minister to everyone, and we speak at the public events and so on. And our fire department, Hartford is an overwhelmingly inner city town. It's sort of like Newark. It doesn't really have suburbs. It's overwhelmingly inner city. It's a high crime rate. Most of our firefighters are from the 2 minority groups that are a majority of Hartford. They're African American or Hispanic. Invariably, these are people with solid families, in spite of the stresses of firefighting, with kids who are going on to do all kinds of wonderful things. People, of tremendous moral values and so on. And all the things and most of them live in Hartford. And all the things that we concern ourselves with the inner cities, and all the issues you raised, don't exist in these families. Invariably, there are 2 factors here. Some of them grew up in pretty negative situations. But there's a few women and a lot of men. The men I know have all made the decision not just to work on their relationships, and by the way, to actually get married. Marriage is quite rare in the inner city. Almost everyone I know on the department is married. And most importantly, things happen, people get divorced, but all the fathers I know are involved in their children. They've made a point of being involved in their children's lives, their schooling, and so on and so forth. And incidentally, almost every one of them is deeply involved in some religious tradition. Quite simply, the Hartford school system spends something like $8,200 a child, which is far more than it costs per child in any Catholic or Jewish day school in our area, and gets abysmal results. Because you can't blame the kids. They have, several people I know in my synagogue, members of my synagogue who've taught their whole lives in the inner city, because they started teaching in the 60s when Hartford became this inner city kind of town. They describe the utter lack of interest or ability. So many of the children are raised by grandparents who are exhausted and tired, and there's an enormous number of parents in jail. Mothers who themselves have all kinds of issues. I don't blame the kids. You maybe don't even blame the parents. But the bottom line is that all the money has accomplished doodly squat, to use the technical term. It's accomplished nothing. What I will say, buckets if you want Yiddish. What I will say is, and I'm not sure how to do it, but I can tell you that remember, there is a New York, the highest court of New York is called the Court of Appeals, right? There's a New York Court of Appeals decision. Again, there was a lawsuit raised against release time. Release time happens to this day. Jews, Christians, Muslims get to take kids out of public school, bring them to a nearby synagogue or church, teach them religious teaching, and then bring them back to school, and they get taken. They get released from school. There was a lawsuit against it from people who protested church and state and so on. So this decision from 1941, I believe, makes the statement that all the institutions of this country presuppose the existence of a supreme being. We have freedom of religion in this country, but this is a country that in its institutions, Congress opens with a prayer, the money says in God we trust. This is a country that has a profound appreciation for religion, not just for shoving it down someone's throat. And so what I want to say is, and by the way, and some of my esteemed colleagues and friends here may disagree with me, I'm a huge proponent of school vouchers for this reason. I think that what the Catholic schools have done with the African American community in Cleveland is beautiful, wonderful. The wonderful education the kids from the African American community have received because there was some kind of limited voucher system put into place for a while. And it doesn't have to be Catholic, it could be, really any religious school. But let me say that I think that somehow, and I don't know if it can be done by legislation, by a Marshall Plan, if somehow we can educate or even push and force or make it a deal you can't refuse for fathers to be involved in their children's lives, for people to marry and form households in which children are raised by two parents, and to encourage in a very subtle way, but at least not to discourage, I think is the word, the involvement of people in the inner cities in religious activities. And certainly not to make statutory obstacles, and if someone wants to send a child to a parochial school, to do everything we can to facilitate it. Personally, since all the states have instituted laws pertaining to public education, I think, and this is radical, you can throw bagels at me if you want or whatever there is on the table, I feel that the state, that the state and local governments should be paying for the secular education of every child in the country, wherever they go. It could be a parochial school, a Jewish school, of any sort. But I believe we should encourage those institutions, strengthen the public schools, strengthen the family, and I'm not quite sure how those things are done, but I think the tax code, work projects, I think there's a lot of ways that your Marshall Plan could be used to do that. But throwing money at people men who will not take responsibility for their children. Senator Obama spoke about this just the other day. Throwing money at schools that have no parents even making sure the kids come to school. I once recently I got a new cell phone number. I have 19 messages, I saved them. 19 messages from 11 different teachers in a certain Hartford school, begging this parent to please, and you see the kid is going down detentions and failures, and this junior high kid is going down the tubes, and I keep calling the school, you got the wrong number. But I can sense the desperation on the part of, I'm sure, these very dedicated teachers. Something needs to be done about this, and without parent involvement, without family structure, without some kind of coherence, I don't see how you're going to help with the money. So that's my opinion.
Thank you very much, folks. It's that time of night. I want to thank you all for participating in our Law Symposium. One last request, several last requests. The Talmud has always been a proponent of saving our environment. These are for you to take with you and recycle by sharing the knowledge with others. Your name tags you can leave at the front to be reused. You don't have to throw them away. Feel free to send out to fill out the surveys and leave them on the table. I hope you all enjoyed the program. We look forward to doing more of this in the future. Thank you for your participation. Have a wonderful evening. Thank you.